In conjunction with the theme of our conference this year, being kind, I personally think when someone can show you genuine kindness by taking a genuine interest in you, that's where I really feel appreciated, and I truly feel that's one of the kindest acts you can perform. That's what you can do to make someone feel like they're interested or that they mean something to you, and to take the time to share what you know, or even to share like an opportunity with somebody. And I'm preluding this with Peter because that's how I look at Peter. We met last year's conference. We didn't know each other from a hole in the ground. We met, we shook hands, see you later, things are good. At the end of the conference, he emailed me. Chit chat, hello, how are you doing? And he gave me some suggestions to help my business, to help who I am as a person, and he didn't have to do that. He just did that out of the kindness of his heart. He took a genuine interest in me, and he shared what he could do for me with me. And that's what kindness really is. So I'd like to really introduce Peter Rickus as a friend. And Peter Rickus is the acting regional program coordinator for the Construction Health and Safety Program in the Southwestern region. He has been in the public service for over 8 years and has worked with the construction sector in technically demanding capacity across multiple ministries and private sector employers. Having spent his formative years traveling through Ontario, Peter now resides in Brantford. In his private life, Peter enjoys the outdoors and tranquility it offers as a stark contrast to the cacophony of raising a toddler. Thanks, Peter Rickus, and thank you. Try and give us a round of applause for Peter.
Hi, everyone, and thanks, Dan, for that great introduction. It's a very good illustration of kindness. My name is Peter Rickus. I'm acting regional program coordinator for the Ministry of Labor, Southwestern region, so that encompasses Niagara, Hamilton, Halton, Brant County, Haldimand, and a few other regions as well. Just before I start, a quick discussion on the role of a regional program coordinator. So you may know construction or industrial inspectors from the ministry, how they come into your workplaces and ask questions, conduct investigations, look for hazards and try to fix those hazards. When they get stuck on a technical problem or are not sure which way an investigation is going to turn, they pick up the phone and call their regional program coordinator. That's me. I give them my version of good advice, which is usually, I wouldn't do that. So that's my role, as a bit of a guide for them. I also look at our region as a whole and the numbers of incidents and where those incidents lie to identify trends. And I use these trends to develop programs to mitigate those emergent trends. So for example, one of the big things that you're going to see in this presentation is that falls in construction are on the rise. And we develop campaigns to mitigate that and dispatch inspectors with resources to take care of those trends before they start to grow beyond our capacity to mitigate them. So that's a little bit about what I do. One last thing about that, it is a roller coaster ride being a regional program coordinator. This morning, I've had about 30 emails already. One of them is incredibly uplifting. A new bill has passed and is now in effect that outlines additional protections for workers and an increase in the maximum fine under the Occupational Health and Safety Act. It's now up to $2 million for certain circumstances. In our strategic policy division, when these bills land and become law, it's kind of like the NASA control center when a moon lander lands. Everyone kind of puts their arms up in the air and goes, yes, yes, all this work that we've done, we're seeing fruition. We're moving the needle on worker health and safety. And that's the top of the roller coaster. But sitting here about 15 minutes ago, I got another email that a worker had died. And I get those far too often. And that's the low part of the roller coaster ride. So a little bit of background about my position, right? We're going to move into the presentation now. And a disclaimer. This is not legal advice. I'm not a lawyer. I don't play one on TV either. And the best advice that I give workplace parties is always consult your own legal aid, your own legal counsel, because they're the ones that are paid to have your best interests at heart. If you ask me, I'm going to tell you what the regulation says. It's on you all to interpret it and make sure that it fits within the specific circumstances of the situation you're describing. So that's my little statement of limitation. So through this presentation, I'm going to talk about the Fair, Safe, and Healthy Workplace Division. We love acronyms in government, and that acronym is Fishwood. That's how we kind of condense that. So I work out of Fishwood. Fishwood is kind of the frontline operations side of the ministry. I'm also going to talk about the health and safety system partners. So there's more than just the Ministry of Labor at work with respect to the overall health and safety landscape. There are other system partners that assist us, and I'm going to describe them because they have resources that might be beneficial to the parties here. Oh, sorry. I'm also going to give you a quick regulatory update. A lot has changed in the law over the last year or so, so I'm just going to give you a little bit of changes to the construction regulations, to the Occupational Health and Safety Act, and there's some big changes to the Employment Standards Act. I'm also going to talk about the numbers, the trends, that what is happening out there with respect to critical injuries and fatalities, not just on construction projects, but in industrial establishments as well. I'm going to go over the court bulletins. So on the ministry website, we release information to the public about entities, corporations, individuals who have been charged by the ministry for violations, what the circumstances of those charges are, and what the fines are. So there's a few important court bulletins that we've released lately that I'd like to share with you. And then finally, I'm going to talk about our health and safety program campaigns. So these are, as I discussed, we identify the trends, we develop programs to mitigate those trends. These are some of the ongoing campaigns that are going to continue through now up until the end of this fiscal year. So when fiscal 2024-25 starts, there may be new campaigns. So moving along here, we can see the Fair, Safe, and Healthy Workplace Division. So I describe this as operations. When an inspector comes to your workplace, or myself, when I come to your workplace, we are dispatched from this division, the Fair, Safe, and Healthy Workplace Division. There are other divisions in the ministry. We have a prevention office. We have a data collection office. We've got OHSB, which is kind of our provincial leads, and training units and other things like you would have with any large government entity. But the people that you meet the most come from Fishwood, the Fair, Safe, and Healthy Workplace Division. And that division has the goal in Ontario to make Ontario the most attractive place to work in the world. And the reason they want it to be attractive to people is because we want our employers to treat everyone fairly and for those workers to come home safely. We've set a mission for ourselves to develop, communicate, and enforce legislation to help make Ontario's workplaces fair, safe, and healthy. And we use our professionalism, our innovation, and collaboration to move the needle on building public trust. So that's the priorities and goals of the division that I work in. But we can't do it alone. We have, like I discussed, partners, health and safety partners that flesh out the landscape of occupational health and safety in Ontario. One of our biggest partners is WSIB. You're going to hear a lot more about WSIB later on. I've got an esteemed colleague who I think is going to speak on that as well. I'll be brief. WSIB essentially provides wage loss benefits and medical coverage for Ontario's workers. They provide no-fault collective liability insurance. They provide support to help people get back to work after an incident. And they have access to industry-specific health and safety information. They provide funding to the health and safety system, including the ministry and our health and safety partners. And they develop health and safety programs for Ontario's employers. Now, who are the partners? So there's 6 major players that flesh out the occupational health and safety landscape. The one that I use the most is the Infrastructure Health and Safety Association. It is an association geared towards specific industries. In fact, all four of the players that you see on this slide are geared towards specific industry. OHSA is the construction side. They deal with construction projects, electrical and utilities, aggregates, natural gas, ready-mix concrete, and transportation sectors. The big one that we see in industry as well is WSPS, so the Workplace Safety and Prevention Service. They support the agricultural sector, the manufacturing sector, and other service sectors. We also have Public Services Health and Safety Association. So the public service has their own health and safety association. So me as a public servant, this is who I would go to for resources when I'm dealing with health and safety issues with my employer. Or if I worked for a municipality or a university or a college, a school board, a library, or a museum, they have resources geared towards those sectors. So if you're looking for resources to help with those sectors, that's where you would look. And finally, we have Workplace Safety North, and they serve, even though North is in the name, they serve the whole province within the forestry, mining, smelters and refineries, paper and printer and converting sectors. The reason North is in their name is because a big part of our mining work takes place in Northern Ontario. There are two more health and safety system partners. I mentioned government loves acronyms. Well, the best acronym I've found in government is OCOW. That's the Occupational Health Clinic for Ontario's Workers. And they provide information on occupational diseases and also clinical services, including medical diagnostic services. So one of the few health and safety system partners that provides actual clinical services for people in need. We also have the Workers' Health and Safety Center. So this is Ontario's designated health and safety training center and provides training for workers, supervisors, health and safety representatives, joint health and safety committees, and employers. Now, WSIB provides funding to the ministry, and through the Ministry of Labor, the ministry funds these health and safety system partners. So that's just an understanding of the way the resources flow. So now that we understand a little bit about the health and safety landscape, I have some regulatory updates for you. So this is information heavy, but there's a lot of good changes coming in law, and I'm happy to share them with you. So working at heights, I mentioned before, falls is a major issue, not just on construction projects, but every workplace, I think, has some level of fall hazard associated with it. As of April 1st of 2024, there are major changes coming to the Working at Heights training provider standard. So the training provider standard is what is essentially expected of the person training you in Working at Heights compliance. And if you have Working at Heights training currently, it's valid. It's going to remain valid until the end of its typical 3-year life cycle. And then when the time comes to refresh, that's when those new training standard provisions are going to apply to you. And what's changing with that Working at Heights training program? Well, we've added a basic reminder to any workers and employers involved that in addition to mandatory Working at Heights training, where you may be required to expose yourself to a fall hazard, there is also a statutory requirement to have a basic occupational health and safety awareness training for all workers in Ontario. We call it worker awareness in 4 steps. Supervisors have an extra step that they get supervisor awareness in 5 steps. So we've added that reminder into the training because we find that that is an area where there's a lot of non-compliance. We've enhanced our copyright rules with respect to the proof of completion of some of these training programs, because over the last 4 years we've noticed a steep increase in counterfeit training cards, not just through Working at Heights, but there are a lot of other training cards out there that are fraudulent in their nature. So just an advisement for everyone, when you're exercising your diligence and checking workers' cards, do be considerate and do follow up. If it looks like it's not legitimate, there is a chance that it's not actually legitimate. That's on the rise. There's a change to the way we submit learner status and proof of completion at the Chief Prevention Officer's office. That's not going to affect the learners. And we've updated the instructor requirements. We're raising the bar on what it takes to be an instructor. And then we're also promoting social inclusion and anti-racism as a part of the components. So that affects construction projects as well as industrial establishments. This next part affects mostly construction projects. So this came through the Working for Workers Act, which introduced Bill 6123, or Regulation 6123. And as of July 1st of this year, it increases the hygiene requirements found in certain sections of the regulations for construction projects. The previous ordering and numbering conventions were a little bit difficult to comprehend, so that's been revamped. And we've also made changes to the horizontal distance that portable toilets must be from where workers work. Previously, we allowed 180 meters. Now we're shrinking that to 90 meters of horizontal distance where it's reasonably achievable. And there were gaps in the hygiene sections as well that, you know, if you're reading them to the letter of the law, made it seem as though there was a requirement to keep bathrooms in good condition, but there was no requirement to keep urinals or cleanup facilities in good condition. So now that's been changed. And additionally, in that same regulation, we've added a new requirement for completely enclosed single toilet facilities. If anyone's worked in the high-rise sector where man lifts are being used to facilitate the moving and cleaning of portable toilets, you will know that there was a time when, and still, you know, we're working to increase compliance, there was a time when the bathrooms that workers are forced to use do not enclose them. They're essentially a moving wall with a urinal or a toilet built into it. So for privacy and their own protection, we've beefed up the standards there. We've also required now at least one designated women-only toilet facility at a project where certain regulations require 5 or more toilets, where it's reasonable in the circumstances. And we've standardized the ratio of cleanup facilities to toilets for multiple toilet facilities. And then since the pandemic of 2020, we've decided to add a requirement for hand sanitizer to the bathrooms in addition to a means of cleaning your hands where running water is not reasonably accessible. So previously, the goal was running water everywhere we can, and then if not, cleanser. Now we're saying if you're going to use cleanser, you also need to use hand sanitizer as well. And another change associated with OREG 61/23 is the, oh, I have a question, yes.
So that second bullet there, where more than 5, at one designated women-only toilet facility on a project where more than 5 toilets are required.
Yeah.
Oh, no, I think I answered my question.
Yeah, so in the regulation, there's a table, and it says if you have this many workers, you need this many toilets of this type or of this type. And at a certain level of number of workers, you reach 5 portable toilets. Now we're saying when you reach 5 portable toilets, one of them has to be exclusively for the use of women on that construction project.
Also, another follow-up question is like the distance, like, so if it's beyond like 180 meters, is there like, so if they provide like some type of vehicle?
Yeah, so there is still an exception in the construction regulations in that section where if it's not reasonable or you're in kind of a mobile operation, if your employer or constructor provides you a vehicle to travel to a bathroom, that is acceptable as well.
Thanks.
Excuse me, quick question.
Yeah.
I work in very remote locations. So what does the law say for that? Because this has been an ongoing issue. Basically, there is no facilities.
Yes. So no change to the remote areas part of the hygiene section. So what we look for in that circumstance is get as close to regulation as you can, given the circumstances that are associated with it. And when an inspector comes to, let's say there's a complaint, we get people fly in camps, and you know, I don't expect them to fly in with a helicopter with a portable toilet hanging underneath them, right? It's just not reasonable in the circumstances. And then how do you keep it clean? Are you flying it in every other day, right? So inspectors are urged to use discretion in those situations and understand that, you know, we're trying to get it as close to regulation as we can, given the very difficult logistical nature of the problem. It's not perfect. We're looking for a solution that fits everyone, and Ontario's construction sector is such a wide and varied place to work that there is no one-size-fits-all approach, or at least that I've been able to find yet.
The issue that we have, it's usually not a problem, but every now and again somebody will bring it up as an issue, and basically we tell them there's nothing you can do. Like, we can put a portable toilet, but there's sometimes where we're 2 to 3 hours going into the bush in rough equipment, off equipment, and you can only service it after those where where our trucks are. So we're forced to go, if we have to go with the bush or whatever.
Yeah, I forget the exact section, but there is an exemption for situations like that built into the hygiene sections of the regulation. I saw a question over here.
Yeah, I was thinking on the point number 2 for the women only. Is it what happens if there is no women on that group? Do you still need that toilet? Because before, I think in the book it was like if there is.
Yeah, so I would suggest there is wording in that section that says where it's reasonable in the circumstance. But if an employer approached me and said, hey, I've got this construction project where I need 6 toilets according to the table in the regulations, but I have no women on this project, so to me it's not reasonable to have one. I would ask them, are you gonna stand at the gate and make sure that nobody here hires a woman to come onto this project? And would they not need, if they did, some sort of bathroom to use? So I push back against the reasonableness as much as I can, because I think it's a necessary step to open up the construction industry.
As a female, when you say women only, if we make that exception, then we'll share it. Is that acceptable? Like if the women on site are being consulted and agreed to share it, or is it specifically women only?
I would look at it on a case-by-case basis, but to me, the regulation is clear. If it's exclusive, designated for women only, right? And I guess I'm kind of mixing language here, because there's a difference between designated and exclusive for, right? So if we designate it for women only, that's a different test to me when I'm looking at a threshold for a contravention than exclusive for. This is new regulation as well, right? So we're not sure exactly what the ramifications for the industry are. We like to know, we like to think that we have a good understanding, but if there's feedback, we're happy to receive it and further develop regulation, right? But we identify it as an area that needs progressive change. Dan, you had a question, I believe, as well.
Yeah, I was just curious, how many people per toilet? Because it says like up to 5.
Yeah, so there's
Is there a number per toilet?
Yeah, and I don't have my green book on me, but it depends on the type of toilet. So there's a difference between a sewered flush toilet and a non-sewered flush toilet. I believe if it's connected to a sewer system and then other certain criteria apply to it as well, 15 people per one toilet, so at 30, you got 2 and so on. And if it's a non-sewered portable toilet, like the one in the picture here, a little porta potty, right? Then it's 9, right? Usually 9 is the number, 9, 18, and so on and so forth. Any other questions? Oh, I see one.
I have a question, just going back about working at heights, if that's okay.
Yeah.
May I ask, you said there's been an uprise in fraudulent cards.
Yeah.
How, does the government keep a list of all, providers that are able to do the training?
Yes, we do, yeah. So Working at Heights training providers are listed in a table on the Ministry of Labor's website. So if you're looking at implementing a Working at Heights training program, the trainer, if you're going to provide provincially approved training, which is what we require, the trainer needs to be certified by the ministry and meet certain criteria. We maintain a list on our website, and in situations where we've been notified of a fraudulent card, we do an investigation, see if that trainer's on the list, and take appropriate actions. So if you like, after I can kind of show you where that resides in our website. Yeah, no problem. Any other questions?
Peter, we look at the ratio of 15 to 1 for regular toilets.
So I'm pretty sure that's the
That's
number.
pretty, unusual, and, it's like a workplace to have, somebody, and do addition of workers. And, I would try to maximize it as much as they possibly can, but politics is not available. And it's so funny that, we brought that up, right, because that's always sort of maps, right? So, I hope the minister will probably review it eventually. The fact at big projects where availability for that.
Yeah, so we look at that table as the minimum standard that an employer must provide. If they're not providing at least that, they are breaking the law. There are also stipulations in the hygiene section that say the use and adequacy and number of toilets must be adequate. So if the table is not working, right, and for some reason, even though they're complying with the table, but there's not enough bathrooms to satisfy new workers or changing workers, we can fall back on that section that says it must be adequate in the circumstances and say, even though you've met the table, there are other factors at play. It's no longer adequate. This is a contravention, please fix it. But I take your comment to heart, and I'll give that advice that the table should be looked at again. Thank you. Anything else? Okay, moving on to PPE fit. So the last part of Ontario Regulation 6123 is an amendment to the construction regulations that requires the proper fit of personal protective clothing and equipment. And essentially what it means is it needs to take into account all factors, including body type. And what I mean by that is that PPE is not a one-size-fits-all situation, right? We see this illustrated through the use of fit testing for respiratory protection. Of course, we know that there's very specific requirements as to how things should fit. So why would we differentiate between things like hard hats and coveralls and gloves and other forms of PPE that if they do not fit appropriately could be viewed as a hazard, right? Especially if you're working near machinery or anything like that. You want to make sure that that PPE is protecting you and not causing issues. Okay, so also in the vein of construction, this is a big change to regulation and a big change to industry. And I don't know if it'll have a direct effect on the people in this room, but we're amending the crane sections in the construction regulation because they are very outdated. So as of January 1st of this year, certain requirements are going to change for tower cranes and other cranes being used in Ontario. And then January 1st of 2025, there are other changes that are a little bit larger, but we're giving people more time to understand them and come into compliance with them. Essentially what the changes are is the clarifying and adding of new crane design criteria, installation, maintenance, inspection, and record-keeping requirements. We're beefing up all the major issues that we see with non-compliance in cranes, and we're putting more explicit language in regulation to control that. We're also requiring a more comprehensive inspection program of tower cranes with reference to a professional engineering standard. So a couple of years ago, the PEO organization put out a new standard for tower cranes, and now we reference that, and we will reference that in regulation come January 1st. And that expands the role of certain engineers working with tower cranes and expands the requirements for them to inspect.
Hey, Peter?
Yes.
Were there some failures or
So a big thing recently, and one of the reasons that the new standard came into effect, is the slew ring bolts on tower cranes. Previously, there was not explicit language in regulation, although anyone doing a deep dive into regulation would read it and say, there is a requirement to inspect these with non-destructive testing. Now we put it explicitly in regulation to test those slew ring bolts. Slew ring bolts is basically, if you look here at my little tower crane, it's the part where the boom is connected to the mast and allows it to spin. So those bolts that connect those two rings together are under a lot of stress. They're constantly needing to be looked at and tested. And now we're putting more explicit language in regulation about it. And we're also clarifying cables, slings, rigging, hoisting sections as well, just to make sure that there's nothing left to chance. All right, starting June 1st, there was that requirement for, under the Occupational Health and Safety Act, for certain workplaces to have naloxone kits available in situations where they are aware or ought reasonably to be aware that they're needed. For a time, there was free kits available from the ministry. I'm not certain if that period still exists or not, but there are a lot of resources on our website about where you can go to get these kits. Employment standards changes. Okay, here's a nice one. So as of October 1st, the general minimum wage went up by $1.05. The student wage went up by $1. Hunting, fishing, and wilderness guides minimum wage has increased, and home workers' wage has increased by $1.15. Nice to see that those employment standards changes are taking effect. Here's a nice one that kind of aligns with a growing concern in government that mental health is not effectively captured in regulation. And I mentioned a bill had passed this morning. Well, my presentation as of that email is no longer fresh because it's outdated. As of now, the sections requiring a written policy on electronic monitoring and also, oh, I missed that slide. And also a policy on disconnecting from work as well. So there's a requirement now for employers to develop a policy on how they expect their workers to disconnect from work when they're not in their working hours. A big step in enshrining mental health in legislation. So I'm quite pleased to discuss that with you. When we're speaking about electronic monitoring, my employer monitors me. They have a policy that explains to me how they do it, why they do it, what they're doing. It's now law that your employer, if they have more than 25 people, should have the same thing.
Can you expand on that? What is that?
Yeah, so requirements for employers that have 25 or more employees. As of January 1st of any year, they must have a written policy explaining the electronic monitoring that they're doing of their employees. The policy must state whether the employer monitors employees or not. The policy must contain a description of how and in what circumstances the employer may monitor their employees, and the purposes for which the information obtained through the monitoring may be used by the employer. My employer tells me it's for my own safety.
Does that mean like computer browsing history or cameras?
It could. It could mean that. It could mean geo-tracking your phone, could mean installing an application on your phone. If you're using a government vehicle, you have a tracker in your vehicle that shows where you are and how fast you're going. And the reasoning behind it is they want to look for employees that are speeding or being unsafe on the roads, or just if your vehicle is left abandoned in a parking lot for 2 weeks, they want to know where you are. Why aren't you there? Is there something wrong? So lastly, from employment standards, and this one is new, and I'll be honest, it's at a very high level. I don't know much about it. It's not my bailiwick. But DIPRA is the acronym we use for the Digital Platform Workers Act. So this is a new act that is developed to essentially help enshrine rights into gig workers and into the gig economy. So people that work under a digital platform now have, when this comes into effect, which it hasn't yet, would have established rights in law for information, established rights for a recurring pay period and a payday, a minimum wage. They have established rights to amounts earned in tips and gratuities, notice of removal from the digital platform, and they should also be free from reprisal. So a very similar set of rights to regular workers under the Employment Standards Act. This would be for workers where the Employment Standards Act does not currently apply. So again, workers in the gig economy. This is a very progressive and forward-thinking set of law, and Ontario is among one of the first jurisdictions to enshrine rights for people that work in the gig economy. All right, let's talk numbers. What you see here is a graph. I plot our fatal incidents and our critical incidents, and I look at how the ministry is performing year over year. And this dashed line here is our trend line. In construction since 2014 up until June 30th of this year, okay, so this data is only the first half of the calendar year. We've had 197 fatalities arising on construction projects. And that's a terrible number, but it's small in comparison to the next few slides I'm going to show you. And I also see this dotted blue line, the trend line is stagnant. It's not increasing or decreasing. And that can be viewed as a negative as well, although I weigh that against the idea that the construction sector is booming right now and there is more work in the last few years there than there has been in the years previously. So perhaps when we take that into account, we might see a negative trend overall in worker fatalities. But this is the only flat trend line you're going to see in this presentation. These are the fatalities in industrial establishments over the last 9 years or so. Again, same time period, 2014 till June 30th. And you can see that the red trend line is slightly increasing. There have been 290 people killed in industrial establishments as a result of a contravention of the Occupational Health and Safety Act since 2014. And again, if you look at the tail end of this graph, you can see a steep rise there. So there's trends that are emerging. Okay, these are our critical injuries. What's a critical injury? Well, it's defined in legislation. It's something that places your life in jeopardy. It could produce unconsciousness. It could result in a substantial loss of blood or involve the fracture of an arm, a leg, but not necessarily a single finger or toe. It could involve the amputation of a leg or an arm or a hand or a foot, but not a single finger or a toe, or consist of burns to a major portion of a person's body, or cause the loss of sight in an eye. So anything meeting that test to the ministry, it reaches that threshold of critical injury in nature, and certain reporting requirements then trigger on behalf of the employers. And what you see here is a very steep trend line. As someone that likes numbers, just a quick aside, when a trend line is linear and it matches the numerical rise in this section right here, there's a part of me that's like, oh, that's very satisfying. It's doing the thing that the averages are supposed to do. But I hate the direction of it. If it was in the opposite direction, I'd be much happier. Now, I do have an explanation for this one. Back in 2016, which is right here, the regulations changed to encompass a wider threshold for triggering critical injuries. So as of 2016, broken wrists, broken ankles, broken bones in your feet, as long as they're not a single toe or a single finger, now are considered critical injuries. So we had a huge spike in reported critical injuries, and that spike continues as more employers begin to understand the new reporting requirements. Still, not a nice trend. And here's the same thing in industrial. A little bit more of a roller coaster ride, not nearly as linear, but a very steep trend, especially since 2016 in critical injuries. So this year, these are the numbers on fatal incidents in construction projects. Part of my role, as I said, is I look at what's emerging, what's coming, and I make programs to fix them. So we can see that in the commercial building construction, 1 person fell to their death this year. And again, this is only up until June 30th of this year, so we're missing everything from July on. In the institutional building construction, 1 worker fell to their death. In the industrial building construction section, 2 workers were crushed to death. And in the single-family housing sector, 1 worker fell from their death, bringing our total so far for the year up to 5. These are the industrial fatalities. So again, same time period, 20 fatalities so far this year. In agricultural, we had 4 people killed. 1 fell, 1 was crushed, 1 was electrocuted, and 1 died by other means. Other means could be anything from drowning to succumbing to an air quality hazard or asphyxiation, a puncture, a stab. In occupational health and safety, we find that there are usually 3 or 4 main contributors to a fatal or critical incident, and then 10 or 20 other little things that make up the remainder. So I would say 60% of our work comes from falls, crushing, struck by, or electrical issues, and the other 40% are all those other things I mentioned: drowning, asphyxiation, puncture, stabbing, and a myriad of other potential injuries. In the automotive sector, 1 person was crushed and 1 person succumbed to other means. In the chemical and rubber plastics sector, 1 person was struck by equipment. On construction premises, 1 person was struck by equipment. In the food, beverage, and tobacco sector, 1 struck by, 1 electrocution. In industrial services, 1 crush, 1 struck by, 2 other means. And then in police, primary metals, restaurants, tourism, hospitality, and rec services, we had each of them 1 fatality this year by other means, and then wholesalers, 1 person was crushed. So what do we do about these things? Well, the ministry investigates. Ministry determines whether there was a contravention that caused the incident. The ministry lays charges as appropriate. So what we can see here is a ring mill press. And a car manufacturer was fined $325,000 after a workplace fatality involving a machine similar to this one. General Motors of Canada at Glendale Avenue in St. Catharines, Ontario. A worker died after falling off the top of a machine that they were working on. The penalty imposed, as I said, was $325,000, and that included that's exclusive of a 25% victim fine surcharge. So in addition to that, 25% of that fine goes to a fund set up to aid the victims of crime. And here are the particulars. On October 22nd, 2021, 2 workers replacing a pneumatic cylinder on a milling machine, just like that one. 1 worker was working from inside the machine, and 1 worker was working on top of it. The worker on the top was not wearing any fall protection. During the worker on top of the machine fell 2.86 meters, just shy of 10 feet, and fell to the concrete floor below and was fatally injured. The employer, by failing to ensure that the worker on top of the machine was wearing fall protection, failed to take every precaution reasonable in the circumstances for the protection of that worker, and in so doing contravened Section 25(2)H of the Occupational Health and Safety Act. That resolved in court on April 26th of this year. In Dundas, Ontario, a concrete products producer was fined $225,000 after a workplace fatality involving a piece of equipment similar to this one. This is called a planetary concrete mixer. And you can see it has these yellow arms and red shoes at the bottom, designed to mix concrete with, cementatious material with water, sand, and aggregate to make concrete. And the particulars of that one, on October 18th, 2021, so roughly the same time, Core Slab Structures, Ontario, Incorporated, uses a steel concrete mixing tank called a planetary concrete mixer in the production of precast concrete products. At the end of every shift, the mixer requires cleaning. Requires cleaning, including the inside of the area where the concrete is mixed. The cleaning requires a worker to go into the mixer through one of the 2 top entry hatches. To ensure the mixer is safe to clean, the employer developed a step-by-step cleaning procedure and provided it to the workers appointed to clean the equipment. The safe cleaning procedure in place prior to the incident included turning the mixer main panel dial to off, applying a worker's own lockout-tagout device to the main power lever, physically turning and removing 2 keys from the main panel, and then placing those keys into each of the hatch locks to allow access to the mixer. Each one of these safety steps, when performed on its own, stopped the mixer from operating. However, the employer trained workers to perform all these steps, right? So the workers are aware what their employer expects. Prior to the incident, both hatch locks had ceased working due to the buildup of concrete and concrete dust within the locking mechanism. Both had been removed for repair, so hatch locks removed. As a result, access into the mixer did not at that time require unlocking the hatch locks with the keys from the main panel to permit temporary access to the operating mixer. On October 18th, 2021, a worker was found fatally injured inside a planetary concrete mixer, and there were no eyewitnesses to the incident. Section 76A of the Regulation 851, which governs industrial establishments, requires that where the starting of a machine, device, or thing may endanger the safety of a worker, control switches or other control mechanisms need to be locked out. The employer failed as an employer to ensure that those measures of the procedures prescribed in 76A of the regulation were carried out, contrary to section 25(1)(c) of the Occupational Health and Safety Act, and thereby they were fined $225,000. So that's the enforcement aspect of producing change in occupational health and safety in workplaces. But we do a proactive approach as well. And we develop programs geared towards the trends. Right now, if you meet a construction inspector, they're going to be focused on falls in the residential sector, both single family and high rise or multifamily residential projects. Up until April 1st, 2024, that's going to be the main focus for construction inspectors. The reason why is, according to information from IHSA, one of our safety partners, falls were the #1 cause of death in construction. Falls from ladders were the leading cause of falls-related deaths in construction. 63% of the work sites where a fatal fall occurred had less than 4 workers on the project. 38% of fatal accidents occurred in the summer. If that was a true average, we'd expect 25%, right? But we can see that there's a trend, more work is happening in the summer. Here's one that I don't like. 45% of those fatally injured workers had less than 1 year of experience in their role. 29% of fatal falls were from heights were among self-employed workers or business owners, so sole proprietors or single operators. That's an important part as well, right? When you consider what's motivating people. We're also looking at things that strike or crush workers in Ontario. So during that same period up until April 1st of next year, we're going to see inspectors taking a focus on struck by materials and struck by equipment at construction projects. Since January of 2017, there's been 192 critical injuries and 22 fatalities resulting from vehicle and equipment strikes. And so our industrial counterparts are doing the same thing. They're investigating and looking at the trends, and they've come up with a campaign geared towards the way material is handled both in the manufacturing sector and in the agricultural sector. Data from last year shows that there were 44 fatalities, which is a great rise from what was in the year prior. And 11 of those fatalities were due to crushing injuries, and 7 were from being struck by something. And it all revolves around the way material is handled in an industrial sector workplace. And then in the farming sector last year, there were 6 worker fatalities, which is a doubling from the year prior. On farming operations, material handling is often a little bit more challenging because things aren't palletized and there may be limited equipment available to help with the movement. So that's the main focus for inspectors at large for this year and probably continuing into next year. This is just a snapshot of the ministry website. So if you're looking for additional resources, you can go to the website to find more information on our initiatives and our campaigns, what we're targeting, our sector plans. So the ministry develops plans for sectors to help them grow and help them build. Our hazard alerts, so when an inspector becomes aware of a very technical or emergent issue, we sometimes issue a hazard alert. There are a few coming out of Southwestern region in the next upcoming months. For specific industry hazards, you can find a lot of good information there. We also have compliance tools and interactive web tools, and that's where we store our prosecution activity or all our court bulletins. I've given you just a small sampling of 2. There are many, many more terrible stories out there. So that's the website. If you have a health and safety complaint, you observe something, you want to have an inspector or the ministry intervene, you can call the contact center at 1-877-202-0008. And it is open 24/7. After regular working hours, it goes to the Spills Action Center, but they action our emergent events on our behalf. And then if you have questions about employment standards like back pay, vacation pay, changes to the minimum wage, you can call our employment standards contact center at 416-326-7160. And that's the end of my presentation. So I'm happy to entertain any questions that anyone might have. I'll give you guys a few moments.
You mentioned that ministry, based on what I've seen in the meetings. And some workers they have they don't know what these are how we access these. It's online. It's on the MOL website. And not only it has the findings, but actually have what happened in that workplace and where we're going to put different steps that was missing. And so it's something that we should share with our workplaces. Safety meetings as we go back to our workplaces. And it shows that the ministry is doing a lot more detailed information on stats and various stats. But it should be in our workplaces so the workers can see and relate to it and assist them.
Thank you, Howard. Yeah, I agree with what he said. Those court bulletins tell an important story, and it's usually gets right to the causal effect of what went wrong that caused that negative health and safety outcome. So each one is a lesson learned the hard way, and we can use those lessons to keep us on the straight path. I see a question at the back. Oh, could you stand, please?
Maybe this is common knowledge, but when it comes to changing something within the regulations, does it come as a result of an accident or an injury or something, or?
Oftentimes. So most inspectors have a phrase in the back of their head that the law is written in the blood of workers. And so a good example is, I believe it was back in 2013, there was a major failure of a swing stage in Toronto in which on Christmas Eve, multiple workers plummeted to their death. And that was the predecessor to a massive rewrite of the regulatory sections that describe what they need to do for their own health and safety in that regard. There are other mechanisms for legislative change, including Ontario's Regulatory Registry, which is a website that all our proposals for reg change are up there and any person can come and make comments. But if you asked an inspector, what they would say is, yeah, it's the result of an incident that we've now become aware of a gap in the system, and now we need to fill that gap. And that's what gets our policy people working like crazy when those things happen. I think there was a question over here.
Yeah, Peter, I know I got you on last year about the mental health. Because right now it's extremely hard to be able to do, like, accept mental health without knowing the diagnosis. Has there been any ways to kind of navigate this? Because you've got to get health information to be able to get a modified work plan. And
Right, about how, as a member of the employer, you can get.
yeah, I know it's more your WSID role. I'm just wondering if from the ministry we're looking at like streamlining any of this.
I'm not sure how to answer that because I'm not sure what other legislation might be out there that describes the communication between a worker when they're talking about their own health and their employer, right? So I'm sorry, I don't have a good answer for you. I apologize. Yeah, so I think I'm out of time. I'll take one last question. I'll push the boundaries.
Okay, for working at heights, is it the employer or the employee that has to make sure that their harnesses are in good condition, and who provides them, the employer or the employee?
Yes, and that means everyone. So, so the worker has a duty under Section 28 of the Occupational Health and Safety Act to make sure that the health and safety devices they've been given are maintained in good condition. The employer has a duty under Section 25 to make sure that the health and safety products that they're giving are maintained in good condition. And if you're on a construction project, a constructor also has a duty to make sure the law is followed. So all the parties have a role to play. Occupational health and safety is it overlaps. There's a lot of overlap for the protection of workers, right? So I expect the workers to know how those things work and are taking care of them. I expect the employer to know how those things work and they're taking care of them and making sure the workers are. And anybody else that's involved, I need them to make sure as well.
Is it the responsibility of the employee to bring their own harness, or is it the responsibility of the employer to provide it?
So the legislation says the employer shall provide. Now, whether they provide it by saying, here, I bought you this, or here's a contract, you've signed a contract saying you're gonna pay for this and I'll reimburse you, or here's an allowance, however they wanna go about it, really the law says it's on the employer to provide it, not pay for it. Okay, I'm going to end my time now. Thank you.